Hello everyone, welcome to Learn Love with AKP. Today we are going to study one of the most famous principles under the Sale of Goods Act, namely Caveat Emptor. This Latin phrase is frequently asked in semester examinations, lawsuit exams, and judiciary examinations. Students often remember the phrase but forget its meaning and exceptions. Therefore, in today's class, we will understand its meaning, importance, exceptions, practical examples, and case law. Let us begin. The term caveat emptor is a Latin expression. It literally means let the buyer beware. The principle places responsibility on the buyer to examine goods carefully before purchasing them. The seller is generally not responsible if the buyer purchases unsuitable goods after inspecting them. Therefore, the buyer must act cautiously and make informed decisions. Under this principle, the buyer must exercise reasonable care before buying goods. The buyer should inspect the goods. The buyer should verify quality and condition. The buyer should ensure that the goods are suitable for the intended purpose. If the buyer fails to take precautions, the law may not provide protection. Now, let us understand through an example. Suppose a customer purchases a second hand bicycle after personally inspecting it. Later, he discovers that the bicycle is uncomfortable to ride. The seller had made no false statements. In this situation, the buyer cannot complain merely because the bicycle did not meet his expectations. The principle of caveat emptor applies. Now, why was this rule created? The rule developed during earlier commercial periods when buyers and sellers dealt directly with one another. The law expected buyers to protect their own interests by examining goods before purchase. This encouraged careful transactions and commercial certainty. However, modern law recognizes the buyers also require protection in many situations. So, although caveat emptor is the general rule, there are important exceptions. The law protects buyers when the seller knows the buyer's purpose, goods are not of merchantable quality, goods do not match their description, goods do not correspond with the sample shown, the seller commits fraud or misrepresentation. These exceptions are extremely important for examinations. Now, section 16.1. If the buyer informs the seller about a specific purpose and relies on the seller's skill or judgment, the seller must provide suitable goods. For example, a farmer asks for a pump suitable for irrigation. The seller recommends one. If the pump cannot perform irrigation work, the seller may be liable. Here, caveat emptor does not apply. Here, merchantable quality under section 16.2. When goods are purchased from a seller dealing in such goods, the buyer expects them to be reasonably fit for ordinary use. For example, a person buys a refrigerator. The refrigerator completely fails to cool items. The goods are not of merchantable quality. The buyer receives legal protection. Now, the sale by description and sample under sections 15 and 17. If goods are sold by description, they must correspond exactly with that description. Similarly, in a sale by sample, the delivered goods must match the sample shown. For example, a customer orders pure cotton fabric based on description and sample. If synthetic fabric is supplied, the buyer can reject the goods. Thus, caveat emptor will not protect the seller. Now, fraud and misrepresentation. The principle of caveat emptor does not protect dishonest sellers. If a seller intentionally conceals defects or makes false statements, the buyer can seek remedies. For example, a seller hides severe engine defects in a vehicle and falsely claims that the car is in excellent condition. The buyer may take legal action here. Now, in the famous case of Ward versus Hobbs, a seller sold pigs through an auction. The pigs were affected by disease, but the seller did not expressly disclose every detail. The buyer purchased them and later suffered loss. The court applied the principle of caveat emptor because there was no active fraud by the seller. Here, the principle established is a buyer must exercise caution and inspect goods before purchase unless a recognized exception applies. Now, modern consumer protection. Here, modern commercial law provides stronger consumer protection than earlier legal systems. Today, implied conditions, warranties, and consumer protection laws reduce the harshness of caveat emptor. Therefore, although the principle still exists, buyers enjoy significantly greater legal safeguards. Now, let us quickly revise. Caveat emptor means let the buyer beware. The buyer must inspect goods before purchase. However, important exceptions include fitness for purpose, merchantable quality, sale by description, sale by sample, and fraud. Let us conclude this today's topic. Caveat emptor means let the buyer beware. The principle requires buyers to exercise care before purchasing goods. However, modern law provides several important exceptions to protect consumers. Therefore, caveat emptor remains an important principle while modern law balances it with consumer protection. For examinations, remember the meaning, rule, exceptions, examples, and case law. Thank you for watching. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP.